the importance of novelty, keeping your ideas confidential. Intellectual property rights are often underpinned by a requirement for novelty, for newness. So if you inadvertently disclose your ideas, you can jeopardize your ability to get a registered right, for example, a patent or a registered design. As a result of this, it's really important to make sure that you maintain and protect the confidentiality of the innovations which you're generating, because otherwise you may prevent yourselves from getting a piece of intellectual property. Registered rights such as patents are incredibly important and powerful pieces of intellectual property. They grant you an ability to take action against third parties in the event they misuse your intellectual property, and they can also be used to commercialise and license to other third parties to generate revenue for the business. As a result of this, it's really key that you maintain the confidentiality in any new ideas which haven't yet been registered, to make sure that you don't prevent yourselves from getting that registration in due course. So why are we talking about this in the context of the factory of the future then? Well, it's quite obvious. There's a lot of innovation going on out there, a lot of collaboration, a lot of development, and we're seeing a number of clients who are really at the coalface of innovation and generating these new ideas that will form the basis of registered rights in due course. My role as an advisor is to make sure that clients, when they're dealing with third parties or their own internal processes, that they maintain a system where confidentiality is maintained so that they can ensure they can have their registered right in due course. What we don't want to happen is an inadvertent disclosure of this new idea, because that will prevent you from getting a registration of a patent or a design, and that's really unattractive when you've invested the time, energy, and effort into this innovation which could be used to commercialise for the business. I've mentioned collaboration. This is a really key area where the issue of confidentiality is key, because when you're collaborating with somebody, there is often a harmonious goal, but sometimes there can be certain conflicts arising. And it's really important to make sure that the parties in any agreement of this nature have got a clear understanding as to their obligations of confidentiality. Because if they don't, somebody who you're collaborating with may inadvertently, or perhaps purposefully, prevent you from getting a registration for a patent in due course. And that can really impact your market position. So my role is to help clients with this, as I've said already, and key area in this is to have a strong contractual framework. So when you're dealing with third parties and you're at the start of this journey to innovate the next big thing when it comes to how you're going to develop, how you're going to grow your business and utilise this technology, I'd encourage you all to make sure that you have a conversation with a legal advisor such as myself to make sure that you have robust procedures in place to make sure that you don't inadvertently prevent yourselves from getting a patent in due course through a disclosure which would impact your ability to get that registration.